Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here with you each and every week at this time on this station to bring you, the landowner, the information you need regarding natural gas development here in Pennsylvania. And of course, and as always, I, Attorney Doug Clark, the Clark Law Firm, have not, do not, and absolutely never whatsoever will not represent gas or pipeline companies. I am here for you, the Pennsylvania landowner, royalty owner, gas right owner. The companies have enough lawyers on their side. We need people fighting and working for you, for this side, to even the bar. And that's what we're here to do. I represent landowners for gas lease reviews, negotiations, pipeline agreements, waterline agreements, royalty issues, deductions, breach of contracts, breach of pipeline contracts, breach of gas leases, estate planning issues, unitization issues, surface use, meter sites, compression sites, buying, selling gas rights, estate planning, you name it. If it's related to oil and gas, give us a call, see if we can help you. You hear me talk a lot about reviews and consultations. It's been a wonderful, wonderful service, and it's been a great experience, certainly for me, and I believe for virtually all the clients as well. And what I'm talking about is if you are presented with any type of an agreement, a document, you're asked to sign something, and frankly, if you already did even, and you want to know what the heck you signed and you want to know what it means, but better to do this before you sign, as always. Remember, people, we need to be putting down the pen and picking up the phone before we sign. Do a review consultation. Really encourage you to learn about the service. What happens is you send me in the documents, whatever relevant documents I need to review. You can always come in person, do them here at the office, or I do them by telephone. I do a ton of these by telephone with clients located all across Pennsylvania, and as you hear me say, all across the country. The clients in many different areas of the country, and even clients located in other countries who have property in Pennsylvania or gas rights in Pennsylvania. So regardless of your location, don't be discouraged about location. With today's technology, get me these documents. We can do group calls. We can have people call in to one conference number from across the country, relatives, things like that. It has worked outstanding. It's been an outstanding experience. It really has. So before you sign, send us, give us a call, find out about the service, see if it's right for you. It usually takes, with the call, about 2 hours, sometimes less, sometimes a little more, depending upon what the issue is and how many documents are involved. So it usually takes, again, it depends on the amount of information, but about an hour, maybe even less to review, sometimes more. And then we have our call or we have our meeting and we go through everything. I answer your questions. I advise you what you should be aware of, what you need to know about. As you'll hear me say, not what the company wants you to know about, but what you need to know about, what you should know about, to answer your questions, to explain, for example, in a lease, how will your royalties be calculated? What items may you be able to negotiate? How can you possibly improve this agreement? Is this a market rate price? Can you improve the bonus? Can you improve the royalty percentage on pipeline agreements? Wow. If you are signing a pipeline right-of-way agreement, and you're not doing at least a review and consultation with me or with somebody who knows what they are doing, I'm telling you, you are making an enormous mistake. I have seen and I have been involved in hundreds and hundreds of pipeline negotiations, and I've been involved in a ton of pipeline negotiations where the compensation paid has doubled, tripled, times 4, quadrupled the amount of money that was initially offered, and many times more. I've had many clients, I'm not saying this happens all the time, but many clients paid $100 per foot of the easement. I want to say that again, $100 per foot. After they were told, I was told, well, all we ever pay, $15 a foot. oh, that's all we ever paid. That's what we paid everybody else. We don't care about that. First off, is it true? And second off, it's the classic thing as a kid. If everybody else jumped off the bridge, doesn't mean I'm going to too. If everybody else signed a horrible agreement against their interest in my area, that doesn't mean I have to do it. Because I'll tell you this, whenever people sign gas leases at $6,000 an acre and 21%, the companies didn't say, oh, well, all these other people signed at 6,000, 21%, so that's what we're going to give you. No, they're going to say, well, this is what the market is now. Well, this is what our leverage is now. Frankly, we're the only game in town. Well, you know what? You need to get across my property, and I'm going to negotiate to maximize my leverage, just like you do in your cases. And again, that's okay. But we need to identify the leverage and understand what we can do. And do we have a choice? Can we say yes or say no? Can we negotiate? What is our leverage? And these are just things. This is an example. I get a little fired up. I'm going to talk about pipelines today. But I get fired up over this because, again, it's just a shame. To me, it's a shame that people are signing agreements. Great people. Farmers, hunters, families have had properties for generations. And I'm telling you, it means something to me as a kid who grew up on the airport road in Armstrong County, Parks Township, Pennsylvania. It means something to me because I worked with my grandfather on the small farm as he also worked in the mill. And I worked on the farm. And I worked on my Uncle Homer's farm. And I worked on other relatives and other people in the area's farm as a kid growing up and see how hard they worked and sweated and were great, great people. And now I know that those great people are being taken advantage of, in my opinion, but I can't have a stronger opinion on this, and we need to stop it. So it's an absolute shame that people are signing these agreements that are extremely company friendly with built-in loopholes all through them for the company to take advantage of you going forward. And what happens, and what's really sad to me, because I think it's a wonderful thing that people like my parents and my grandparents were great people. My grandparents were great people, trusting, honorable people. And they've since passed, but I could see my grandfather and grandmother being taken advantage of because they believed and trusted in people that stood in front of them and told them things, they believed them. If they were told, we're going to put one pipeline in the ground, we're going to do it in the next year or two, and you're going to get this money, people believed it. Then all of a sudden, or my grandparents would have believed it, and then all of a sudden multiple lines go in. Line doesn't go in when promised. One goes in. Years later, another one goes in. When they were told, oh, this means no deductions on your gas lease, if they were told that, they would believe it because they didn't tell people lies. They weren't dishonest. They didn't mislead people. And they expected the person sitting across from them to treat them the same way. And the problem that we have is that I often use the example, my dad, I talked to him the other day, he sold all his hay out of the field, or not all of it, but a bunch of the hay out of the field. And those transactions are done with a handshake. And a lot of times they're not even shaking hands. Hey, we're going to do this. This is how much? Yeah, okay. And that's the transaction. And that's how they're all done. And so that's what you're used to. But then here comes in these companies, which literally have multi-billion-dollar companies. It's not an exaggeration. Multi-billion-dollar companies. And they're coming in to deal with you and your property, whether it be several hundred acres or whether it be just simply several acres. And what do you think they're going to do? You're not dealing with your handshake neighbor who's going to buy hay out of your field. You're dealing with a Fortune 500, Fortune 250 company who is out to do one thing: maximize profits. Not your profits, their profits. That is the fiduciary obligation of the company to the shareholders. Never forget that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus. Also, if you're looking for representation, learn about reviews, consultations, see if we're right for you. give us a call, 570-307-0702. 570-307-0702. I want to help everybody I possibly can. I truly, truly do. Go to the websites, pagasleysattorney.com, pipelineattorney.com. Look at the testimonials, read the information on the websites. This is what we do, and it's who we are. And I really want to hear from you. And if you have these agreements, I want to help you. Do the review consultation. Well, if you think it's right for you. And I'll tell you, I don't have people at the end of these calls saying, boy, why did I do that? How come we did that? I've never had that happen yet. And I hope I never will, but it's never happened yet. So it's proven to be an outstanding service. And I want to say this, just this past week, we're making strides. We have been for a while. I've been doing this show since 2010, August of 2010. Think about that. And so we've been getting this information out there, and we get, calls all the time. And I'm very, very proud to say that we got a call. Well, we got several, but some calls about the multi-unit well consents, multi-unit wells, where I have been preaching. If you have a multi-unit well consent and you're not giving us a call, I'm telling you, you're making a mistake. I'm telling you that. And so we had people call and say, hey, I hear Doug on the radio. I got a multi-unit well consent. He says, hey, I should give you a call. And I can't tell you how happy that makes me. Not because, oh, great, I have a client. No, because I'm really confident I can help you. And to myself, I know that I can help you. I know I can. And that makes me happy. What a great job that you get to help people. And a lot of times, this help can be resulting in the clients getting literally hundreds of thousands of more dollars, and sometimes even millions of more dollars, and even especially over time. And the vast majority of the work that I do is just an hourly rate. So I really encourage you to give us a call and learn about these services. And it's not so much, I'm so fortunate to have the work that we have, but it's the opportunity to continue to benefit people, to make these agreements better, to make your personal agreement better. And I'm going to tell you, we do it. I do it all the time. And I'm confident that the worst thing that can happen on a review and consultation, the worst thing for you that can happen is you now understand everything, your questions are answered, and you decide what you want to do. That's the worst thing, that you get your questions answered and you understand everything. The best thing can be the same thing. You get all your questions answered, you understand everything. Now you understand you have the right to say no, and you understand you have the right to negotiate, and you have an idea of what your negotiation leverage is. And usually we get a plan together on how to negotiate and what to do going forward. And then you decide how you want to handle that. I'm telling you, it's worked out fantastically for the clients. And it's a great thing for me too, because I get to, again, make sure on an individual basis that you understand before you sign or before you decide not to sign what your options are, what your leverage is, and you make your decision as to what's in your best interest. And again, guys, I'm telling you, it's usually an hour or two. So as you hear me say, look, put the pen down, pick up the phone, give us a call, 570-307-0702. See if we're right for you. And if we're not, that's okay. I think you'll find that we may be, but if we're not, that's okay. But I really want to help everyone we can. So really want to keep encouraging people to call. So like I was saying, somebody called with multiple people call with multi-unit well consents. And I'm so glad that they have, because I know in my mind that I'm going to be able to help them. Another thing, I know we're getting the word out there because more and more people are saying when they call in, hey, I hear Doug on the radio, stop signing, stop signing. I can't tell you how many times people say, we learned our lesson from last time. Let's not make it, we learned our lesson from last time. I mean, if we have to, that's okay. It's never too late to learn our lesson. But let's also, if this is your first experience, Don't be a person who 5 years from now says, I learned my lesson from the first time. No, let's come into this knowing what we need to do and maximizing your situation. So I'm going to talk about pipelines today, and I'm kind of, as always, pipelines are one of my favorite subjects. I know it may sound strange, but there is often significant leverage that the landowner has to negotiate for more money, and many times substantially more money than what is offered. Again, many times you can negotiate for significantly, substantially more money than what is offered. You need to make sure that you understand if you have that ability. And then from there, to negotiate language and restrictions in the document. And I'm going to go through an example of a pipeline agreement. And I'm going to talk about clients that I'm working with now who we have tremendous leverage to negotiate. And I suspect they're going to sign agreements for significantly, and I mean a lot more money than what was originally offered. And I know that the terms are going to be outstanding, and they're going to be very fair, and the landowner is going to get a great agreement. I know that's going to happen. I've done it many, many times before, and I know it's going to happen. And I'm going to go through this agreement, and I'm going to illustrate how when you sign these agreements, you're giving this company and these companies tremendous authority in the future, and simultaneously eliminating any ability to negotiate or protect yourself or if you don't care about yourself, your children and your children's children. These are great examples, and they are all true. So stick with me. This is going to be a fun show. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Call anytime. Love to hear from you. See if we can help you out. Remember, any issues, 570-307-0702. We are here for you, not for companies, for you. 570-307-0702. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus. Also, if you miss any of today's show or any other shows, or you're new to the show, go to the websites and you can listen to prior shows. There are, probably 50 to 100 hours of radio shows available on the website, all kinds of different topics. Websites, I should say. I'm going to talk about pipelines today. I say this, if you have anything to do with the pipeline, if you are presented with a pipeline agreement and you're not going to pipelineattorney.com, you're making a mistake. Go there, get information. Just get general information. Become more educated. It's not specific advice. The show's not specific advice, but get information. Give us a call. Do a review and consultation. But get information, because the goal is for you to do the best you can. So how are you going to do information or do better? Lack of information? No. We got to get you this information. And again, I've done negotiated, consulted on, worked on pipeline agreements now with over 70 different companies across Pennsylvania. And of course, always on the landowner's side. That gives you an idea of the experience and information out there. So if you have a pipeline agreement, and again, you're not doing a review and consultation, and they're all with me personally, not an associate and a younger attorney, with me, give us a call and let's get set up and see, get you this information. And look, if you don't like what you hear, that's okay. Call somebody who knows what they're doing. But we have to stop listening to company landmen and representatives and saying, okay, that sounds good, we're going to sign. You need to protect yourself, whether you're doing it when we talk or you're doing it with someone else who knows what they're doing. You need to protect yourself, your property, and the property and your children and generations to maximize these agreements. And if you're not doing it, you're making a mistake. So let's get into some substance here. So right now, I am working on multiple negotiations on behalf of clients where years ago when we entered into the first, or the client entered into the first pipeline right-of-way agreement, They did it, and it restricted the pipeline to say, or the easement area, to one line only. And now the company wants to come back and put a second line in. So we have the ability, and I say we because I got to tell you, I guess that's how I look at it in some ways, but the client is the client's decision is always, but the client has the ability to simply say no or negotiate, and then negotiate potentially for significantly more money because the company doesn't have the authority without the landowner's written permission to install a second line, and the company wants to do it. So again, the company has installed one line years ago, now wants to come back and install a second line. So think about, again, you have two different construction events. They tear up the property, they put in the line, they reclaim it. Hopefully they do a good job. Now here they come back, they're going to do the whole same thing again. So certainly you should be compensated, but many times you just sign that form agreement and you have nothing else to say. So because we limited the first agreement to one line only, the client is in an outstanding position in this round of negotiations. Outstanding. And think about this. When the company has the right to put the second line in, they don't come back to you and say, oh, well, we're going to be real nice to you and do such and such or give you some more money because we're going to put a new line in. No, they say, hey, you signed the agreement, we're going to do it. Well, company signs the agreement committing to one line only. You have the power to say no or negotiate for more money. That's the rules. But then the company wants to make you feel guilty or say, oh, well, you should give us a break. Who should be giving who a break here? Think about that. Who should be giving who a break? Should you, the farmer, landowner, whatever your occupation may be, recreational property, should you be giving the $5 billion, $50 billion market cap company a break? Or should they be giving you a break? Or should you negotiate to maximize your leverage because darn well that's what they're going to do? Well, I think multiple things. You need to be making sure that you're maximizing your situation because that is what the companies are going to do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus. So because we restricted to one pipeline, we're in an outstanding position to negotiate here this next round. Similarly, in water line agreements, a smart attorney is going to seek to restrict the water line to transport only fresh water, not what's called flowback or produced water which returns from after fracking, when they inject it down into the well, when they frack, and the water comes back out. So that is very salty, has contaminants in it. And so a lot of people don't want that water to be transported through pipelines across their property because if a pipeline leaks or there's a problem and that water aquifer is contaminated, well, that's an enormous issue. An enormous issue. So many of my clients say, hey, I do not want to see that produced or flow back water transported across my property if I can help it. And then we talk about, do you have that right? And then we talk about, can we restrict it? So I've seen multiple clients, past clients, where we've restricted to fresh water only, where the company now wants to come back and they come back to request the ability to transport produced or flow back water, so what we would call fracking water. So the people can say no, or they could negotiate to make sure they're going to be protected in the event of a spill. They can negotiate to say, hey, look, I don't want to do this, but if I'm going to, it's going to take an enormous amount of money because you could destroy my entire property and my drinking water. So this is what it's going to cost. But those people, because they had the foresight and they hired an attorney who knew what they were doing, restricted these initial agreements and now have put themselves in the ability or in the position to either say no or to negotiate to a price and terms to be added to the agreement that would justify them agreeing to this new request. And that's what we want to do. We want you as the landowner to have options in the future. If you're going to sign an agreement, we want to have you have options in the future to reject something or to negotiate if you negotiate to the point where you would find it acceptable. That's a good job in the pipeline agreement. And also, clearly, maximizing your compensation for each and every single agreement. And let me tell you, does the landman say these things to you? Does the company employee say these things to you? Well, as we know, of course they don't. They work for the company, not you, the landowner. And again, that's okay. That's okay. We need to know that. And we need to know what their job is. And again, that's okay. But we have a job. You, as the landowner, have a job to protect your own self, to maximize your position. You've had this property for who knows how long, and many, many times it's been in the family for generations. That many people have made their living off of that property. And you need to maximize your current situation, protect your property today and into the future, and give yourselves opportunities to say no or negotiate again in the future. And I'm going to tell you, in almost all cases, we can do that. We can do that. And here's the deal. The company isn't going to do that for you. Again, the company is not going to do that for you. You need to understand your rights. And I'm not going to go too far down this path, but I'm telling you, if you are getting told, that's all we pay, this guy signed for this, so that's what we're paying you, I don't care. I don't care, and neither should you. Just because everybody else signs a bad agreement, sure as heck doesn't mean you have to as well. And it doesn't work that way. It doesn't work that way, and we need to stop that. We need to stop signing because somebody else signed a bad agreement. That's crazy. We have to stop doing that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, okay, I'm going to go into, so I'm saying, like, because we've negotiated these other agreements, I have these clients now, several of them pending right now, where we're just in a great negotiation position. And these are really fun things to work on. Really, really great fun things to work on because we hold a lot of cards on our side. And how do we hold those cards? Because of the foresight years ago when we did the original pipeline agreement, we negotiated in restrictions, which we thought may come into play in the future. And when you are somebody who deals with pipeline companies all the time and issues that arise thereafter, you know, hey, here's what we need to protect against. Here's something that happens all the time. How can we make this better? How can we do better for you? What do we need to put in here? Where are the loopholes? How do we close these loopholes? That's what we need to do. And that's why I say, the review, I'm going to probably say it again, but reviews and consultations on pipeline agreements, but at least the same thing, regardless, any document, are just so darned valuable. And they only typically take about 2 hours, beginning to end. Typically. If you send a book, it's going to take longer, but typically, that's what it takes. So avail yourself of that service. Give us a call and find out about it. Again, 570-307-0702. So let me tell you this. I'm going to go through some terms of a pipeline right-of-way agreement. So this is going to give you, I hope, some indication. And people are just signing this. Again, people are just signing these. So here's the agreement. It says that it's a right-of-way and easement agreement. And it starts off with that saying that it's going to be a 100-foot permanent easement. That means from one side to the other. The width of it, not the length, but the width of the easement is 100 feet. If you want to, but go out and measure 100 feet and see how big that is. That's a large swath of property, 100 feet. And then measure that 100 feet, or if you know what 100 feet looks like, think about what could a company stick in and fit in a 100-foot wide area that runs across your property. Well, I'm going to submit to you an awful, awful lot. Some of these FERC interstate 36-inch pipelines are in easements that are only 30 feet wide. these multi-state, these going from state to state pipelines, some of them are in permanent easements that are only 30 feet wide. Many of them are in easements that are only 50 feet wide. Major interstate pipelines going from state to state are within easements that are only 30 typically to 50 feet in width. But yet, this gas company wants an easement 100 feet wide. Literally 3 times, more than 3 times wider than these multi-state lines going from state to state, 30, 36-inch diameter pipelines. They're in easements 30 to 50 feet, but the company here wants a 100-foot easement. Again, to me, that's generally unacceptable. 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 And if you're going to agree to it, you better darn well know what this means. And you better know what can they do within this easement area. Well, you know what? We'll take a break here, and we'll get into what they can do. And again, as you may suspect, it's going to be scary. But this is where you need to negotiate. You need to understand the power of these agreements. And then you need to understand how to defend yourself and make sure that you're not giving more than you need to. And boy, doesn't the company want you to sign this agreement? Heck yeah, because you're going to hear why. My heavens, why do they want you to sign this? You'll find out. You'll find out. Stay tuned. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. And give us a call. Learn about representation. As you know, I have not, I do not, and I will not represent gas or pipeline companies. Give us a call. See if we can help you, regardless of the issue. 570-307-0702. And again, regardless of your location, give us a call. We're here to help you. 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus, and give us a call. See if we can help you. 570-307-0702. Any negotiation, any oil and gas matter, breach of contract, you're shut in Tioga County for 8 years or more and you have 50 or 100 acres or more, I want to hear from you. This is outrageous and we need to stop it, and we're going to do everything we can to stop it. So especially 8 years or more, 50 or 100 acres or more, and you're shut in, these vertical wells that are shut in, we have to do something about it. This is not right, and we're going to do everything we can to stop it. So I want to hear from you. Multi-unit well consents. If you're not calling, my opinion, you're making a really big mistake. Multi-unit well consents. If you're not calling, I really am telling you, I think you're making a major mistake, because I really believe I can help you. So give us a call, any of these issues and more, 570-307-0702. Now let's get back to this agreement. This should give you an idea of why you need to be careful. You need to put the pen down and pick up the phone, and we need to stop signing bad agreements. So this is a pipeline agreement. This is a real agreement. People are signing this. People today are signing this. This is an active agreement being presented to people in the Tioga, Potter County area, but this could be other places. So I don't want to just limit it to an area. Remember, these same principles apply all over. Maybe some agreements are a little better, but a lot of times they're not much. And I'm telling you too, this isn't the worst agreement I've seen. So we're just going to highlight this one. So the permanent easement, remember, is 100 feet wide, permanent easement. So when it's all done and over, they own a 100-foot wide, they have an easement, 100-foot wide across your property, however long that easement's going to be. A 100-foot permanent easement, my opinion, should be very, very highly scrutinized, because why are you agreeing to such a large permanent easement? Interstate pipelines with diameters of 30 to 36 and sometimes 40 inches are often within easements that are only 30 feet wide. That means that the company in this case is requesting an easement over 3 times wider than the major interstate pipeline easement. Sometimes those are 50 feet, but still then, this company is requesting an easement twice as wide as what these interstate easements that are interstate pipeline easements that have 30 to 40-inch diameter lines. They're in 30-foot to 50-foot easements. Why does this company need 100 feet? Well, we better be darn sure we know what the company's allowed to do. Well, here we go. What is the company allowed to do? Well, you grant them the permission to, and I'm going to paraphrase, to lay, construct, maintain, improve, add, alter, inspect, operate, repair, replace, relay, listen to this one, relocate, remove, substitute, change the size of anywhere within the right-of-way area, including with the adjacent temporary right-of-way, or they can also abandon their pipelines in place. They can, one or more pipelines, they can also install one or more pipelines, whether above or below ground, including, but without limitation, temporary surface lines. And what can they transport? Oil, gas, related hydrocarbons, related oil products, liquid, condensate, crude, petroleum products, natural gas liquids, liquefied minerals, and other hydrocarbons, water, including but without limitation, fresh and produced water. Oh, and how about this one? In case we didn't cover every possible thing, how about this? Or any other substances that can be transported through pipelines from your property or any other lands. Then also, let me just pause for a second. So think about that. Think about those rights. Unlimited number of pipelines, the ability to change the size, the ability to relocate the pipelines and the easement. Think about that. Think about that. That's what this says. I don't care what you're told. That's what this document says, and that's what matters. So what else? Well, it goes on. They have the right to install. You might think, how can it go on? What else could there be? Well, they have the right to install all necessary and convenient ancillary equipment, which is including, but of course not limited to. So these things, listen to this. Valves, tap valves, tie overs, drips, connections, fittings, meters, markers, cathodic protection, graphite and steel anodes, and other devices for the control of pipeline corrosion. Well, there's more. Rectifiers, pig launchers, receivers, related facilities, measuring and data acquisition equipment, and appurtenances thereto, using methods and techniques not restricted to current technology. And to perform all necessary pre-construction work. And we have to be done, right? Well, no, we don't, because there's more. To install electric power and telephone services, electric equipment. And by the way, this agreement further states that the company has the ability to assign, meaning to transfer rights to another company or another entity or even a person. They have the rights to assign, or the ability to assign the rights that you're giving them in whole or in part to another company. Meaning this, that if you give it this gas company, because you think, this is a gas company, they're telling me, the landman says, we want to put one gas pipeline in, we're going to make you rich. Well, you just signed an agreement. This language here that I just went over allows for electric lines, it allows for telephone equipment, telephone poles, you name it. You've given them a 100-foot easement. So this gas company can say, hey, electric company, if you want to use these easements, we'll sell them to you, but we don't have to sell them all to you. We'll just transfer you our right to install telephone lines or electric lines. And we'll sell those rights to you, and you can use our area of the easement. And you as a landowner can't do a darn thing about it. Nothing, because you agreed to it. Or, like we do whenever we can, which is in most cases, limit to either one line, or we define the number of lines and we define the timing of when they can be put in. But if you limited this to one natural gas pipeline, you don't have to worry about those other items. Or you can negotiate when they come back. And if other people are just going to sign and do whatever the company wants, and you're smarter and you realize, hey, wait a second, I'm not going to get fooled and taken advantage of, and you protect yourself, you're in such a greater position in the future. You're in far better position because maybe everybody else allows multiple lines, telephone lines, electric lines, but you don't. So you stand in a great position. Great position. So you're now, just let's pause and regroup for a second. By the way, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You've now, what we've gone over, agreeing to a 100-foot wide permanent easement, which is very, very wide. You're agreeing to an unlimited number of pipelines, and you've heard what I just said of all the different types of surface activities you're agreeing to. You can have meters, valves, pig launchers. You can have all these things all over your property. You could. That's what you've agreed to. Electric lines, telephone poles, cables. Company says, oh, we're not going to do that. We're just going to put a pipeline in. Good. Then we'll limit it to exactly what you're telling us you're going to do. Think about that. They sit at your kitchen table and tell you this is what we're going to do. Say, fine. Then let's put it in writing. Shouldn't be a problem, should it? Let's put it in writing. And then look, again, many times, that's what we do. That's what we do. So we'll go on. So it's a 100-foot, remember, permanent easement. It goes on that the company shall have the sole and absolute right to select the exact location of the pipeline and the equipment within the right-of-way and the temporary right-of-way. The company also has the right of ingress and egress, meaning travel over and across your property and lands contiguous thereto to the right-of-way as provided, together with the right to construct roadways. So, you have just given them the ability to go anywhere across your property to get to the right-of-way, and they can make a roadway to do it. And they say, we only need to put a pipeline in. Well, okay, let's get rid of that as well. And again, we almost always, or in most cases we can, and if we can't, we know they want to put a roadway, or they need that right to put a roadway, and we negotiate and you get paid for it. You just sign this agreement. You've literally given the ability to construct roadways across the property to get to the easement. And you've given them a meter site. You've given them a valve site. You can have a roadway to it. And I've dealt with clients. I've dealt with landowners who've dealt with this issue after the fact, where all of a sudden my one client comes, the $1 million road goes all across their property because they signed an agreement that allowed it. And what happens when they complain and they say, oh, a landman told me he was just going to be one pipeline. What the heck is this $1 million road across my property? Here's the response. You signed the agreement. You signed the agreement. So you better well know what the heck you're signing so you don't hear that response later. You got to understand that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Want to go on here. Okay, I'm going to hit one more of these before the break at least. So it goes on then that this is its own sentence in its own paragraph all by itself. Landowner expressly acknowledges and agrees that the company may construct more than one pipeline or water line within the right-of-way, which means they can put as many dang pipelines in that 100-foot area as they can fit, above or below ground. No other way around it. And in theory, they could put one pipeline in every year, every 2 years, whatever number we want to pick, and dig up that property time and time and time again. They could put 10 pipelines through there, 10 different occasions, and dig it up 10 different times. And if you didn't negotiate for money or you didn't negotiate limit, there's not a darn thing you can do about it. And they can put above ground lines. If you're farming in that area, well, you're going to have a problem because you got these big above ground lines there. So you have to be aware of this. Let's do one last one here. Finally, it says, well, I shouldn't say finally. The next one says that during the periods of construction, repair, maintenance, or testing, or at roads, railroad crossings, streams, ditches, or other areas that require more difficult procedures, the company may use an additional temporary strip of land up to 25 feet in width alongside of the right-of-way as may be necessary or convenient during periods of construction. This is called the temporary right-of-way area. So now we have a 100-foot permanent and a 25-foot temporary. So that area being cleared, go look at some woods in your property if you have woods, or look at woods anywhere. But think about how much of an area 125 feet wide is. 125 feet wide, almost half a football field cleared across your property. Do you think they're doing that to just put one line in? Maybe, maybe not. Okay, there's more, of course, to go. We're up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me every week at this time on this station. Give us a call. You get one of these agreements. We got to put the pen down. We got to put the pen down and get you the information you need. I hope you're seeing this in my book is outrageous. It has to be limited, and you can do it. We can do it. Learn your rights. Give us a call, 570-307-0702. Unfortunately, there's more bad to come, and we're still in just this one agreement. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on the station. Give us a call. Learn what we can do. See if we can help you. 570-307-0702. I want to jump into this because, again, it gets even crazier. So here is the pipeline right-of-way agreement that we're using as a sample today. If you miss any of today's show, go tomorrow morning, pagasleaseattorney.com, pipelineattorney.com, and anytime, and check out the shows. So this goes on to state, this agreement, that you agree that after you grant this agreement, that you will not grant another right-of-way or surface lease within the right-of-way or temporary workspace to any other pipeline or utility right-of-way, for a pipeline or utility right-of-way. So you're limiting yourself there. You need to be aware of that. But this gets worse. Location. People, again, these companies are smart. They give you a map, so you think this is where it's going to be. And maybe that's acceptable to you. But you have to go deeper. You can't say, oh, Landman told me this is where it's going to be. Here's the map. This is where it's going to be. Because you have to read and you have to understand what these words say and how they can be applied in the future. So by executing this agreement, you consent and agree to the location of the pipeline and the temporary right-of-way as shown in the exhibit map. So there's a map showing you where it is. But that's not the end. Unfortunately, that's not the end. It goes on that in the event the company desires to change location, not you, but after you sign, if the company desires to change location of the right-of-way and temporary right-of-way, as shown in the exhibit map, they shall give you a written request seeking your consent to change the location. However, you cannot unreasonably withhold or delay or condition the consent to the change. So whatever you agreed to, they can submit to you something totally different where they actually want to put the line. And then if you don't consent to that and they say you're being unreasonable or you're delaying, you can be in a lawsuit because that pipeline is going to get moved and they're saying you're being unreasonable. You better darn well know what that means. That is a very, very bad provision for you. Very, very bad. Here's the deal. This is no joke. This is not exaggeration. This is the truth. Here is the deal. They show you this is where we want to put the pipeline. This is where you agree to the pipeline. You think you're set. Landman says, oh, yeah, this is where we want to put it. However, they then change their position. Who the heck knows if they always knew they were going to change your position, get you to sign what you would accept, then come back later and do what they actually want to do. And then when you say, hey, I don't want it there, they say, well, you're being unreasonable and we're going to put it there anyway. Try to stop us. And that's what you just opened yourself up to here. Oh, and by the way, it's a 100-foot permanent easement that anything that they can think of essentially can go into this easement. Unlimited lines, unlimited surface structures of any and all kinds that fit in within the 100-foot easement. So now, you thought you agreed to a small easement in the corner of your property or in the edge of your property. Now they want to go diagonally through your property, and they say you're being unreasonable when they want to change. And what are you going to do about it? Are you going to go into court? Are you going to file an injunction to stop them? What are you going to do? You better well be aware of this, because this is an enormous problem. So, again, companies are smart. Oh, people want maps. Maps make people comfortable. Give them a map, but give us, the company, the ability to change that map. Get them to sign a map as to what they will agree to, but put language in the agreement that says if we, the company, desire to change the location, we can do so, and you can't unreasonably withhold your consent to a new location. Get pen on paper, landman. Get pen on paper, company employee, and then we can change it if we want, and they can't withhold their consent in an unreasonable fashion. And who's going to decide that? Is it going to be you? Is it going to be the company? Or is it going to be a court or an arbitration panel? This is bad stuff. Bad stuff. And you have to be aware of it. You have to be aware of it. You need to get rid of it or limit it. But boy, you better be aware of it. Now, goes on. I talk about, landman works for the company. I don't care. Landman says, oh, we're going to put one pipeline, and here's where it's going to be. Here's your map. Well, listen to this. This agreement contains all the understandings of the party, supersedes any other agreements, oral statements that were made. Then it goes on that this kills me. For the purpose of construction, meaning interpretation of the document, it shall be deemed that the landowner and company contributed equally to the drafting of this agreement. You may say, what the heck? Let me explain this. Here you have this very detailed contract that you sign, and you're agreeing when you sign that if a court is ever going to interpret this, or an arbitration panel, that they are to interpret it as you and the company contributed equally to the drafting of the document. Think about that. Think about that. What in the world did you contribute to the drafting of this document? Nothing. But yet you admit that you did, so that nothing can be construed against the company when they're interpreting the language of the document. Again, not good. How many of these not good things do we need to see before we say, hey, wait a second, we better change this? You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Last thing I want to say on this agreement goes on to state that the landowner acknowledges and agrees that any person or persons negotiating the terms and conditions of this agreement on behalf of the company may be an independent contractor, also known as a landman, of the company, and is not its agent or employee, that such person or persons has no authority to bind the company to the agreement or otherwise, and that this agreement or any other promise or agreement shall not be binding upon the company until the agreement is accepted by the company as evidenced by the due execution of the agreement by an officer or authorized person of the company. Meaning, landman has no authority, so we can reject anything. Earlier about the entire agreement, any written or any oral statements, we're going to put one pipeline, this is what we're going to do, we're not going to put anything above ground, doesn't matter. None of that matters, and you need to be aware of it. These are unbelievably enormous loopholes that have to be closed, that have to be minimized, that you must be aware of. And once you sign, you can't go back. I've hit the end. Boy, I hope you listen hard. Give us a call, 570-307-0702. And remember, the landman works for the company, not you, the landowner. Put the pen down, pick up the phone, stop signing bad agreements, and keep listening each and every week at this time on this station for All Things Marcellus. And have a great, great week, everyone. We'll be back next week.